What is special needs planning? Special needs planning is the process of providing for the personal and financial security and well-being of yourself or a loved one. If you don't plan now, the government may make certain decisions and choices on your behalf, and those decisions and choices may not be what you would want. For example, if you are no longer able to provide for your loved one's personal or financial needs, a court may appoint a guardian or conservator who would not be the person you would choose. Or if you fail to provide for your loved one by executing a valid will, state law will determine what your loved one will inherit, and that might not be what you intended. Even worse, if you fail to plan ahead, there may not be enough money for the proper care of your loved one for the rest of his or her life. So it is vital that you put financial plans in place to make sure this does not happen. The goals of special needs planning are to balance your present and future needs with the present and future needs of your loved one. Create and implement plans that meet your loved one's personal care needs as well as his or her financial and legal needs. Communicate those plans to all persons involved with the care of your loved one. Review those plans on occasion and revise them as circumstances change, and provide peace of mind to you and your other family members and friends. Special needs planning includes a number of specific steps. Your plan should create and implement a personal care plan for your loved one. Create a transition plan for the continued personal care of your loved one as circumstances change. Create and execute a legal plan, and create and implement a financial plan. You should also consider the need to preserve your loved one's eligibility for state and federal government benefits, such as Medicaid and supplemental Social Security income. Why? Because in order to be eligible for some government benefits, the applicant can't exceed certain minimum income and asset levels. If your loved one has access to more financial resources than the government allows, he or she won't qualify for benefits. So, an important part of your special needs planning should focus on your loved one's eligibility to receive available government benefits. The federal government, most state governments, and many private organizations offer resources and benefits to those with special needs. Proper planning will allow your loved one to first tap into any government benefits to which he or she is entitled, permitting you and your family to use personal resources to provide for additional support and comfort. One of the most important planning techniques involves the use of a special needs trust, which is sometimes called a supplemental needs trust. Special needs trusts were given official legal status by Congress in 1993. Typically, a trust is considered an available asset whenever someone applies for a means-tested public assistance program, such as Medicaid or SSI. A special needs trust, however, is an exception to this general rule. Assets in a properly drafted and administered special needs trust are not counted as available assets, and trust disbursements will not be counted as income under the rules that apply to SSI and Medicaid. This is what makes a special needs trust such a valuable planning tool for someone with disabilities. Are you concerned about your loved one's future personal needs and financial security? Are you concerned about meeting both your loved one's needs and your own? If the answer to either of these questions is yes, you need to understand your options. So ask questions and start planning now.